Hello, everyone, and welcome to another episode of the TCLF One-On-One Series. Through the One-on-One Series, we aim to interact with the best legal professionals from India and around the world. In the technological domain, blockchain has been the buzzword for quite some time now. Legal practitioners and scholars around the world are trying to decode its interface with different fields of law, and that is exactly what we are going to do as well. We'll be talking about the interface between blockchain technology and antitrust law. We couldn't be more honored to have another fantastic guest with us, Ms. Deeksha Manchanda. Ma'am is currently a partner at Chandhiok Mahajan. She is a 2011 graduate from NLIU Bhopal and went on to pursue her master's from the University of Oxford as a Commonwealth Scholar. She has tons of experience in the field of competition law and has been a part of some of the landmark cases ranging from cartel investigations to abuse of dominance cases as well. Ma'am, thank you so much for joining us today. It's truly an honor.
Thank you so much, Shashwat. It's a pleasure to be here on the forum and to interact with you and all the other students through the platform of this forum.
Just to set the tone for the conversation, ma'am, can you please tell us about your journey in the field of competition law? How did you begin, and how has your experience been so far?
So my journey of competition law began in college. I was in National Law Institute University, and around my third year, which was 2008, we knew that the act is going to be enforced in some time now. And that's when one of our faculty members, Professor V.K. Deeksha, decided to take a session and a seminar course in competition law, which was my first brush with law. And it probably had to be a little bit of who was teaching and perhaps a lot to do with what the law was about. I found myself extremely interested in the way it worked. There was a beautiful mix of law, economics, logic, all of it coming together very nicely. And that's where the interest started off. I did, in fifth year, you had the option of doing a dissertation. So I did that on merger control regime in India. There was very little to go by. So it was largely what the combination regulation should look like, because at that point of time, the commission was thinking of coming up with the regulation. And finally, I made my way into practice after my master's, started off with Luthra and Luthra law offices. And then through my journey here I am, Chandhiok Mahajan. Overall, it's been an extremely interesting journey, largely because the area of law is so interesting. You get to know of each and every sector in such a nuanced way that is probably not possible for all other practice areas of law. So I think I like that about it. There's no way for you to get bored in this practice, because with every new client, you would be dealing with new challenges. So even though the law is very small, it's three effective sections is what we're dealing with. Within those three sections, there is so much and so many different implications for different industries that you would never get bored of.
Absolutely. And I think the fact that when you graduated, the field was in its very nascent stages. The act has just been enforced, as you talked about, and the practice was just developing in India, and that must have made it even more interesting as to how the field would look like in the future and how things would go about in the future. That must have made it even more interesting for you. So, just to delve into the topic of the conversation for today, as I mentioned, blockchain has been the buzzword, in the technological domain for quite some time now. So, can you start by telling us what the technology is all about? What are its essential features?
Sure. I think the word blockchain is actually self-explanatory to a certain extent. So what we're looking at here is a record-keeping technology where information is stored in blocks, and then these blocks are connected to each other. Now, what that leads to is essentially a ledger. So, what people in accountancy would be aware of, we're basically looking at a ledger, but it's a ledger which is not centralized. So it's not any one person controlling it. It's a ledger which, depending upon the nature, is likely to be open to all people to view, except if it's private in nature. And it's something which is distributed. So it's not, again, stored in one place or at one node. So which is, these features combined imply that the technology is it's not centralized with any one person, so it's decentralized in nature. Two, because you have the verification of each of the information in each block is going to be done by multiple people and then stored in multiple places. That means it's immutable. It's not easy to change the information that has been stored in a block. And overall, that means the technology is much more secure. So a very easy way of looking at a blockchain is to think of it as a ledger system which is extremely secure because it is not being controlled by a central repository and none of the entries are being confirmed by one particular person.
Right. So, looking at the essential features that you've talked about, decentralization, distributed ledger, and all of these things, what really comes about is that inherently blockchain technology is neither pro-competitive nor anti-competitive, but it has the potential to be both. And CCI has recently published a discussion paper on the interface between blockchain and antitrust law. And let's start by talking about the positive side of things. Uh, how do you think blockchain technology can create some pro-competitive effects, or how can it help consumers in the long run?
So I think as a technologies are generally neither pro-competitive nor anti-competitive. They tend to be neutral, and it depends upon how and to what use you actually put that technology, right? To a
Right,
certain extent, one can say that if there's any technological advancement, it's bound to lead to some kind of ease and efficiency, increasing overall consumer welfare. So I think the bend of technology is always towards inherent nature is probably always towards being pro-competitive unless it is used for anti-competitive purposes.
right,
Now, when we talk about blockchain technology, as I said, we're talking about a very secure ledger system. So if you
right,
think of it, you essentially you have a very, very good basis of record keeping. And record keeping can be used across industries. You name it, and the industry is going to have the need of keeping some records, right? So you can use it in financial services, you can use it in healthcare, because it's essentially adding an element of decentralization and efficiency to your record keeping. And if it is public in nature, which means if the blockchain is such that it can be accessed by any person,
right,
and it's not limited to a certain set of people, then you're also ensuring that it's transparent. Your
right,
record keeping is transparent, but at the same time, it's secure. So it can
right,
have usages in a lot of industries for maintaining of these records. That's one pro-competitive usage. And especially if you're talking about the government sector, where let's say welfare measures have to be carried out and implemented. We know, for instance, of the direct beneficiary scheme that the government of India is carrying out and how it has actually helped in making the welfare measures much more efficient. So that kind of usage can be achieved through a blockchain technology as well, where details of the beneficiaries and the fact that money has been passed out to them can be recorded in secure ledgers. So that reduces the possibility of records being tampered with.
right,
Similarly, in the medical sector, where health data has to be stored, and there are often concerns about how safe is my health data in a particular place. A private blockchain would perhaps be a very good way of storing your healthcare data without and ensuring that it doesn't really get tampered with. And the second area is again a derivative of blockchain technology, which is something called as smart contracts. It's again linked to blockchain, derived from that technology. You're basically looking a contract, the way you would understand at a very basic level, is certain obligations that two parties have to fulfill for each other, right? Now, if these obligations can be verified by blockchain technology, then you have what is called a smart contract. So then I don't really need an intermediary. I don't need a court. I don't need any kind of an enforcer. I need you and me to have entered into a contract which clearly defines the obligations that each of us have to fulfill. There is a method to verify that electronically and to store that information on a blockchain so that our transaction gets completed. So I think there was, in fact, this one example in the CCI's report itself, where an airline company uses a smart contract for giving out refunds if the flight gets cancelled. So it's easy. I have to make a booking for a flight on day X, It can be verified whether the flight on day X took off or not. If it did not, automatically my refund or some kind of a token or whatever has to be issued gets issued to me. So what you're bringing about is an efficiency in storage of information, and B, an efficiency in conduct of parties. And you're probably eliminating the need for any kind of an intermediary. I don't need a travel agent now. I just need to have entered into that smart contract with you, which is going to automatically verify information, store it on a blockchain ledger, and there we are. So I think that is one of the biggest pro-competitive things that the technology can do for us. It can make life pretty much like any other technology, way more seamless for everybody concerned.
Just before I move on to my next question, I'm sorry, we just need this clarification, and we have this doubt. What is the difference between a private and a public blockchain, and even more between a permissioned and a permissionless blockchain?
Okay, so I probably should have covered this in response to your first question, so my apologies there. But you broadly have four characterizations of a blockchain. You have a public blockchain, and then you have a private blockchain. This characterization is essentially based on accessibility to the blockchain. A public blockchain is going to be accessible to the public at large and not going to be limited in who can access it and who can't access it. On the other hand, you will have a private blockchain, which is only accessible to certain people. So that's the one characterization. The other is permissioned blockchain and permissionless blockchain. Now, permission blockchain is basically where to participate in the blockchain, which means to submit or to verify transactions on the blockchain, you need to get a permission. Permissionless, on the other hand, means I don't need the permission. Now, your blockchains can be a combination of both of these. So you can have a public permissioned blockchain, and you can also have a public permissionless blockchain. So when I say accessibility, that accessibility for public and private is essentially viewing accessibility. Right? So you can have a blockchain where to participate, I need a permission, but it is accessible to the world as at large, which is going to be a public permissioned blockchain. Or I could have, on the other end of the spectrum, a private permissioned blockchain, which means that I can't access it. It's limited to a certain group of people, and I need permission to verify and to participate as well.
Right. Thank you so much. I think that makes it even more clear as far as the characterizations of different blockchains are concerned. And this leads me to my next question, which is regarding the negative effects. I think the lack of any central authorities. You've mentioned that all parties have a stake in that ledger, and there is no central authority. So that lack of central authority can lead to enforcement issues for these competition authorities. Basically, in very simple terms, who do they recognize as the player who initiated a particular anti-competitive agreement, or things like that. So how do you think that this ledger can be used to facilitate anti-competitive agreements?
Okay, so there are two parts to it, and I think I'll deal with both separately. First, how can you use it for an anti-competitive agreement? So let me concentrate more on cartels here. Now, you see what blockchain is doing is that it's storing information, right? It's validating transactions, maintaining a ledger, storing information, which means it can also be used to store competitively sensitive information, be that pricing information or supply information, or by way of a smart contract between me and XYZ, it can also be the future conduct that a party may take. Now, all of this information, if it's in the hand of my competitors, if it's a public blockchain where these things can be viewed and seen by my competitor as well, that means I'm actually transmitting or exchanging information. So a blockchain can actually facilitate a cartel conduct. That's one part of it. But it can also help you monitor a cartel, because in a cartel, part one is to actually enter into an agreement and say, okay, you and I are going to maintain X price in the market.
Right.
But then the more difficult part often is to actually maintain that cartel, to monitor that cartel and to enforce that cartel. Blockchain might actually give you a very easy way of doing that, because information is easily available. it's easily accessible, it's verifiable, it's secure, it's not incorrect.
Right.
So you can verify whether the decision that a cartel participants have taken is being implemented. And by virtue of smart contracts, you can also ensure enforcement. So deterrent mechanisms can be put into place where, if you were supposed to maintain price in the range of X and X plus 10, and you go below that or you go above that, then immediately a smart contract can come into play, which may make certain payments to the cartel participants to retribute them for you moving out of the conduct of the cartel. So that's how your blockchain can enable an anti-competitive arrangement in the sense of a cartel. It can also do so in sense of a vertical agreement, but there you're looking at a blockchain as more like a platform for people to interact. So issues could be pretty similar to what we deal with. For instance, you're compulsorily linking your blockchain usage to a wallet, because you use currency in a blockchain, which is what Bitcoin is, like cryptocurrency. So you use particular wallet for those cryptocurrencies. Those could raise concerns of anti-competitive vertical agreement.
Right.
But I would say that there it essentially remains same. It's just the platform and the product linkage is a little different, but largely remains the same. For cartels, it might actually enable things to happen a lot more easily.
Right.
So that's how that anti-competitive bit in a blockchain is going to work out.
Right.
But you had a larger question, which is, I think, a more complicated one, which is how to identify the responsible parties.
Right.
Now, in some sense, when we're dealing with a company as well, we're dealing with a monolith creature, right? And parallels can be drawn between that and how a blockchain is going to work for you to identify responsibility. So it is going to be on the actors, but yes, that pinpointing of where in the blockchain and in which nodes or which participants are the one who are enabling this conduct, that could actually pose a bit of a problem for the commission. I think that's one area of challenge that only with developing greater understanding of how a blockchain could work in a cartel type scenario will it be possible. But I would imagine that for a cartel, you would actually maybe have a private permissioned blockchain which is being used. So it would be easy to pinpoint responsibility. But if somebody manages to use a public blockchain, then yes, I agree. It's pinpointing that liability is going to be difficult for the commission.
Right. And I don't know if it's far-fetched or only hypothetical or theoretical in nature, my question, but I think another issue that would come about is how to basically determine the existence of the agreement itself, because that would again require the understanding of the technology itself, because to prove an anti-competitive agreement first we have to see whether there is an agreement at all. So I think that would again be a challenge.
To a certain extent, yes, but I think the definition of agreement is very broad under the Act.
Right.
So when action and concert is covered as an agreement, then you can look at that parallelism in the market and say that, your participants of blockchain, and we see that the prices in the market have been similar to you. Looking at the ledgers, we see that the information that has been stored is effectively price sensitive information. So I think it may not be that difficult, but yeah, the base here would be understanding how the technology operates. I think minus that, the CCI, not just the CCI, any enforcers, practitioners, all of us would be grappling, in the dark, because you actually need to understand how it works for you to be able to identify where and how you can identify that agreement's existence and where to pinpoint liability.
Which basically brings me to my next question. And you characterized, you give an example of a private permission blockchain, which can lead to a lot of effects in terms of recognition and enforcement and everything. So I think this private permission blockchain can also lead to abuse of dominance issues, wherein certain competitors can be kept out of the loop and certain competitors can be allowed by one particular dominant entity to access that blockchain, and thereby restrict the access to information that should be available to all, I think. So do you think that's possible, and that's a consequence as well?
Abuse of dominance, I think, is an alive concern with the technology. Of course, there's no
Right.
denying that. But when we talk about abuse of dominance, and specifically when you talk about access, what has to be ensured and first determined is whether that blockchain is necessary for a competitor or a downstream or upstream entity to survive in a market.
Right.
Because I can abuse my dominance at all three levels, right? And in fact, at the fourth level of the end consumer as well. Now, is the blockchain essential for these people to competitively offer their products or goods or services in the market? Is the first step that will have to be crossed. Until such time that blockchain technology doesn't start touching threshold of being, an essential facility, or being a gatekeeper that nobody else, you're the only way for me to reach the market. Till the time it doesn't reach that status, I don't think a valid abuse claim can be made. But the possibility of that not happening in the future, of course, cannot be, you cannot close your eyes to it. We are in a world where technology is evolving at an extremely rapid pace. And even though blockchain has been around for some time now, we've seen that, increasingly there'll be uh, more and more usage of technology in every sphere of our life. And the
Right.
minute blockchain starts getting intertwined somewhere in that supply uh, cycle for us, for the end
Right.
consumer, the possibility of it being abused in some form cannot be outruled. So that's a very alive concern. But as I said, we probably will have to wait till the time the technology itself reaches that level of dominance. So it's maybe not something to be immediately worried.
Right. Which brings me to the last segment of this conversation, and I have uh, a twofold question for you. As you've talked about, there is a need to understand this technology. So, how can the CCI in particular and the Indian regime prepare itself for the issues that are going to come about? What should be the way forward? And secondly, like since there have been no cases in India, but uh, have there been any cases outside India, or how have the other regimes, tried to deal with it?
So dealing with the first question first, I think a very brilliant step that the Competition Commission of India has taken was the paper that they recently issued on blockchain technology. What that shows us is that the regulator is alive to these new technologies, and there's very active effort to understand these technologies. Because as I said, for any enforcer, step one will be to understand how the technology works. Only then you can move forward and understand how it is harming or benefiting competition, right? So the first thing would be for the regulator to arm itself with the requisite knowledge. And I think CCI is on the route of doing that. The paper represents two things. Number one, that we are trying to arm ourselves. And number two, it's a guiding paper out there for the world at large, for the technology, people who are involved in the technology to understand how their conduct can impact competition law. Because
Right.
often what we feel when we interact with companies is that they're not very alive to the fact that competition law exists and they can end up breaking it.
Right.
So it's a good paper because it puts out that your conduct can have anti-competitive implications.
Right.
So please be careful. It's very balanced, thoughtful paper, and I
Right.
think working in this direction is a best way for the regulator to prepare itself. The
Right.
more knowledge that they gain, the more guidance they can impart to the
Right.
industry, which would probably help prevent these practices from happening in the first place. But even if they
Right.
do, we have a regulator who's understood it all. So we can expect swifter decisions, which will be
Right.
important in the technology space. We can also expect balanced decisions, which don't interfere too much with the growth and development of the technology. So, a little hands off approach to let things play and
Right.
regulate only when necessary. And I think all of that will come if and as and when the regulator tries to evolve itself to understand these technologies, which the
Right.
CCI is.
Right. And like
And
I think just before that, I think it sends out another message, and that is, I think it provides a kind of an avenue to companies to entities, and it says basically the message goes about saying that the CCI is aware about the competition concerns that can come about in this technological space, and if need be, we can step in when necessary. So they're basically providing an avenue to these companies that we are aware of the situation and we can take adequate steps if necessary, I think.
Correct. Absolutely. Absolutely.
Right. And the second question, ma'am, what have other
Yes.
jurisdictions done?
Other jurisdictions, it's blockchain is not something which is up on the radar right now of the competition authorities. There is
Right.
one art case which is going on before the courts in the US, which is essentially about a dispute between the participants of a blockchain and
Right.
about which one would continue to retain the earlier blockchain. And there was another pair which forked out, which led
Right.
to some impact on the financial market.
Right.
And it's there are allegations of cartelization as well in that case, to say that
Right.
these people cartelize together to push up and down the prices of the stock. But
Right.
more than that, it's largely an issue of investor protection. So I would say that it's um, it's not a very hot topic right now for any
Right.
jurisdiction. But everybody is aware of the fact that this could be something that could come up and become very important. So I think, much like India, other regulators are also probably in the process of understanding how the technology can impact competition and to what extent would a regulator need to step in to stop
Right.
anti-competitive conduct from happening.
Right. I absolutely concur with that. And thank you so much, ma'am, for these wonderful insights. And particularly, it's been a very learning experience to have this conversation with you. Just before we, come to the very end of this conversation, any final piece of advice to competition law enthusiasts in India and around the world?
First of all, thank you so much for having me here. It's always an amazing experience to talk and discuss. It opens my mind as well to new ideas and possibilities. So I think it's fairly mutual, the game that we have. As a competition law enthusiast, I've been, I strongly believe this myself, and so I keep telling everybody there is no shortcut at all to being good at what you do. Hard work is the only way to achieve it. So keep reading, keep if you are genuinely interested in competition law, the CCI website and the Compact website should be two places that you regularly keep checking for new orders. Keep checking out what's happening in the EC and the US. It's those are the only ways to expand your thought process about the law. Subscribe to blogs from which you can get to read articles and stuff about competition law. There are a few good ones out there. And just generally, our mind is such that the more you read, the more fine-tuned it becomes. So just keep reading and
Right.
challenging yourself to newer notions, and that's it.
Well, I absolutely concur with that, ma'am. And like from my limited experience, uh, studying this law, what I can vouch for is that there is no dearth of literature or material. Scholars around the world, are spending a lot of time exploring new issues. And the more you read about it, you get to know that there are so many avenues, that this field can offer, not just as a practitioner, but also on the academic front as well. So with that, I would just like to say thank you once again. And just before we end this conversation, on behalf of the whole Contemporary Law Forum team, I would also like to pass on this message to everyone that please take care of yourself and your loved ones. We're living in some tough times, and this is just an attempt that we can do from our side, is to just keep imparting knowledge that wonderful practitioners have to offer. And yeah, just please take care of yourself, and if we can be of any use to you, please do not hesitate in reaching out to us. Thank you.